Hi, my name is Ken Fickler. I'm the founder and CEO of Gaze, and today I'd like to talk about reasonable suspicion and employee impairment testing. So, when an employee is suspected of being under the influence of drugs at work, it can be really difficult to know what to do next. And a lack of clarity around the legal definition of reasonable suspicion, employee drug testing laws, as well as variation in employment law between states, has led some employers to making mistakes that are extremely costly and can create legal action against them. With a little knowledge about these issues and how to deal with them appropriately, you can typically avoid getting yourself into trouble, though, when dealing with suspected impaired employees. So, what is reasonable suspicion? Reasonable suspicion is a legal term that governs what action can be taken by an employer if they suspect an employee could be impaired at work. It's a lower standard than probable cause, which is used by law enforcement, and it allows employers to conduct employee drug testing based on a reasonable belief that the employee could be under the influence of drugs or alcohol. Reasonable suspicion must be established by objective facts and not just subjective beliefs. So, for example, if an employer observes an employee staggering or slurring their words and appearing intoxicated at work, this would provide reasonable suspicion to conduct a drug test. Employers must be very careful to document their rationale for reasonable suspicion, as employees may feel singled out if they're being pulled aside for a drug test and other employees aren't. And this can, of course, lead to legal action against the employer and the loss of a valuable employee. When should you drug test an employee? So there are several situations in which reasonable suspicion drug testing is appropriate. Now, this is when you suspect an employee is impaired at work, when an employee has a medical condition or is on that medication that could affect their job performance, when an employee has recently been involved in an accident or near miss at work and you want to determine if there's anything that could have contributed to it. If the employee was involved in a car crash, for example, it would be reasonable for HR to request a drug test so they can rule out impairment as one of the causes of the crash. And lastly, when an employee is behaving unusually and seems like they're under the influence of drugs or alcohol, but not necessarily just feeling drowsy. Certain types of employees are required to be tested given the nature of their position, and this includes employees that are in law enforcement, national security, the protection of life and property, public health or safety, or other functions that require a high degree of public trust. These are all required to undergo drug testing. This involves safety-sensitive industries like transportation, defense, hospitals, schools, universities, and any federal, state, and county organizations. You can learn more about those requirements on the SAMHSA website, which we've linked below or in our blog post. What are the reasonable suspicion signs of drug use? So reasonable suspicion signs of drug use may be different for every state, so be sure to chat with your attorney about what's legal, but they typically include some physical signs, and those are defined as visible changes in the appearance or demeanor that indicate that a user is under the influence of drugs. And these can include dilated or constricted pupils, bloodshot eyes or glassy eyes, rapid unexplained weight loss or gain, unusual odor on the body or breath, for example, cannabis, smoke, or alcohol, flush, pale, or sweaty skin, shaking, body tremors and twitching, frequent sniffing or runny nose, swaying or staggering, and needle marks. This can also include behavioral signs, and those are defined as a change in behavior that indicates a deviation from normal for the individual that could indicate drug or alcohol use. And these typically include a loss of focus, concentration, or motivation, hostility or irritability, a decrease in work efficiency, increase in workplace accidents or near misses, unusually long breaks away from workstations, falling asleep at work or sleeping at times where there is no reason for it, slurred, delayed, or mumbled speech as well. Last is results from a drug test. Positive results may indicate recent use, but they may also not be able to be conclusive about impairment because some drugs remain in someone's system for much longer than others. So, for example, cocaine is relatively short-lived versus marijuana. The THC from marijuana use can be very long-lived in a person's body. How do you document reasonable suspicion? Reasonable suspicion is a serious matter that needs to be documented, and the documentation can be done in many forms, including a memo or an email. But it's recommended to keep the documentation with the employee's personnel file. And it's also recommended to standardize the reporting form. So rather than using a memo or an email, we've linked a reporting form below, and you can see the blog post for more information. Documentation should include the time and date of the event, as well as the name of the person who conducted the evaluation and noticed the behavior to begin with. It should also include details on why you believe there was reasonable suspicion to test the employee and what actions were taken to confirm or refute that suspicion. Once the results of a drug test are available, they should also be included in this report or memo. How to legally drug or impairment test an employee. Now, as of 2024, there are no laws in the U.S. that prevent an employer from conducting impairment testing for reasonable suspicion, and in fact, many Gaze customers do this today. This can be either instead of or in addition to traditional chemical drug testing. Impairment testing is a great first line of defense that can help to confirm or deny reasonable suspicion and inform the appropriate follow-up chemical drug test. There are several circumstances in which an employer can legally drug test an employee without cause. Generally speaking, this includes testing during job applications and for employees in positions that mandate testing by the U.S. federal government. Most states also allow random drug testing of employees, although some don't, so be sure to check with your attorney to find out about your state. If an employer wants to drug test an existing employee using a chemical drug test and they are not legally required to be tested, the employer must follow strict guidelines to remain legal. In order to legally drug test an employee without cause, you must have had a reasonable suspicion that they are under the influence and are working in a safety-sensitive position. This can be defined as any job where there is a risk of injury or danger that could result if the worker cannot perform their duties safely. Some examples include pilots and truck drivers, but probably not office staff or sales associates unless they perform a safety-sensitive role. Employees have to sign off on consent forms before being tested for drugs at work or randomly, and these must be administered consistently according to the company policy. What mistakes are commonly made in reasonable suspicion and employee impairment and drug testing? Impairment and drug testing are important aspects of ensuring workplace safety. When you suspect that an employee may be impaired at work, it is important to be aware of the legalities associated with drug testing them. Here are a few of the most common mistakes that employers make in impairment and drug testing. 1. Not following a formal, written company impairment and drug testing policy. Now, this is the single most important step that each company should take to ensure that they're maintaining a safe work environment. Once you have a policy, you need to also follow it, and there can be major legal challenges if a company policy is not administered consistently. 2. Not testing when you have reasonable suspicion of impairment. It can be tempting to simply send an employee home for the day if they show up drunk or high, but it's vital to document the incident and follow what your company policy says the appropriate next steps are. If you don't, it can really lead to legal troubles down the road, like when you actually have to do an impairment or drug test on someone and they claim discrimination. And that leads us to number 3, not treating all employees the same in drug testing. Favoritism and discrimination are major legal problems for employers, and you have to be fair in how you create your drug testing policy and in how you execute on it. Number 4 is applying Department of Transportation or DOT rules to all employees. Now, the DOT regulates certain types of employees for certain industries that touch transportation, and you should only regulate your DOT-covered employees using those rules. Applying DOT rules to jobs that are outside of DOT purview is not allowed. In conclusion, if an employer suspects that an employee is impaired on the job, they can be legally required to perform a drug or impairment test. And if that test comes back positive, the employer can then take disciplinary action against the employee. This can include termination or suspension of employment, but it should be clearly documented in your employee manual, and each employee should sign off on that policy when they accept employment. Impairment testing using Gaze is the fastest and cheapest way to discover workers who are impaired on the job. We don't have any per-test fees, and the results are available in just 6 minutes, so you can operate a safe and efficient work environment. Please contact us for more information, and thanks for your time today.